Good day, viewers. You're welcome to another episode of Tomi Talks Legal, where we bring the law to you in the language that you will understand. So today is going to be an interactive session where we'll be answering questions related to will, making of a will, and who can benefit from a will. So after listening to this episode and you have other questions, I will be glad to answer them as long as you drop them in the comments section. I will be there to answer you. What is a will? A will is a document that contains the wish, desires, plan of its maker, writer, or testator upon his or her death. What does this mean? This means that a will only be valid, or a will will only take effect when the person who made the will dies. And in a will contains the wishes, the desires, the plan of its maker upon his or her death. What does this mean? This means that inside a will contains how someone or an individual wants his properties, investments to be shared when he or she dies. And this will can only come to life or take effect when the owner or the maker dies. So who can benefit from a will? The only person that can benefit from a will is the beneficiaries. Who are the beneficiaries? Or who is a beneficiary? A beneficiary is someone whose name is contained in a will and has been given one or two properties, either tangible or intangible, in a will. So if in a will it is written, give Tomilola Daniel the sum of 2 million naira that I have in my bank GT account, blah, 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 so and so. Tomilola Daniel has become a beneficiary of that will. Now, is it possible for someone who is not a beneficiary of a will to benefit from it? Which means, is it possible that someone whose name is not mentioned in a will to inherit an asset through that will? The answer is a big no. But we know that to every general rule, there is an exception. So the general rule is anybody whose name is not contained or who is not a beneficiary to a will cannot benefit from the will. However, there are exceptions. And the major exception to this will is when the person that is exempted from benefiting from a will is a dependent. Now, who is a dependent? A dependent is either the child, the legitimate child, is the legitimate child or wife of the deceased person, of the testator, or of the maker of the will. So where you are a legitimate dependent or you fall under the description of a dependent, you can contest a will where your name is exempted. Let me give an example. Where you have a man who has a child outside wedlock, the man now happens to die and exempts that child from the will. When the man dies and that child knows of the father's death, the child can approach the court to contest the validity of that will. And the court will look into the matter. Once the legitimacy of that child can be proved, such a child or wife, as the case may be, cannot be disinherited. So the only exception to this rule is where the person exempted from benefiting from that will is a legitimate dependent. There are also circumstances where a legitimate dependent is mentioned in a will. However, the testator or the maker of the will has stated clearly in that will that he or she does not desire that dependent inherits anything from his or her assets, where it is expressly stated that this person has been disinherited in a will for whatever reason or the other, or where this person has been disinherited from any of the deceased assets, there is nothing that such dependents can do about it, because it is the desire of that testator that person or that dependent should not inherit any of his or her assets. This is why I always say that ensure that you have your will or write your will or make your will. Your will is not a death sentence. Rather, your will lets the people know your mindset towards how you want your property to be administered, to be distributed, to be used when you die. So when a dependent is validly exempted from benefiting from a will, there is absolutely nothing such dependents can do. The next question I will move to: does a beneficiary of a will have to share with siblings not named in the will? Now, where you have a large member of family, or you have a large family, and some dependents have been validly exempted from the will, and the siblings, desire that, okay, what do we do, in order to avoid enmity in that family, especially when that property is jointly owned by the family members? One thing that I want you to have in mind is, once a will is written and a property or an asset has been bequeathed on you, or has been given to you, or a property, as you've inherited a property, you as the beneficiary has now become a legal owner of that property. When you become a legal owner of that property, it means that you can choose what you want to do concerning that property. So where all the family members agree as joint owners, or you as a person agree as an individual owner, or you decide as an individual owner to share part of the property or the revenue of that property with your sibling or with your disinherited sibling, it is absolutely your choice, and there is no law that speaks against that. So you can validly, single-handedly, upon your own decision, decide to share the proceeds or the revenue of such property owned in common, or the revenue of that property that you own with your inherited sibling. And there is no law that speaks against it. It is only morality, you can decide to share such revenue, or to co-own such property with the disinherited sibling. It is typically based on your discretion. There is no law that supports or goes against you validly sharing the proceeds or co-owning that property with your siblings. Why? Because you, as a beneficiary, you are now the legal owner of that property. So I will move to my next question. Can a testator revoke or amend his will during the lifetime? Yes. You can amend the will amend your will rather, as many times as possible during your lifetime. But there are certain guidelines that has to be followed for you to amend your will. So for you to amend your will, you just don't write, put it in black and white and say, okay, that my will that I wrote so time, like you're updating a document. No, it has to be amended either by destroying the previous will and writing a new will. We know that from time to time, people, update, how will I put it now, increase their assets or sell their assets. So as, time goes by, if it happens that maybe you've sold one asset or you've gotten a new asset, or someone does something that impresses you and you feel, upon my death, I want this person to inherit from my property. Or you feel at some point in time that, I have changed my mind about, my previous beneficiaries, and you want to automatically change, or include new beneficiaries in your will. Ensure that you write another will or you amend the previous will by doing a new will or a codicil. But be sure that you cannot validly write a new will or write a codicil or amend your will through a codicil without the proper guidance of a lawyer. As I would say before, get a lawyer for everything and anything. If you do not want your investment to go to waste, if you do not want your property to be shared in a manner that you do not desire, ensure that you write your will today. Get a lawyer to help you, guide you on how to write a valid will. If you have any questions, comments, or observation, please drop it in the comment section. Be sure that I will be there to answer you. And once again, kindly subscribe to my YouTube channel. Click on the like button, and if this video has been beneficial to you, kindly help me share it generously with your audience. Till I see you again in my next episode.